Let's talk about separate property and community property in estate planning. Hey everybody, I'm Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. If you have estate planning or probate needs and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, community property versus separate property. I get these questions so quite often, and I thought I would just try to break it down for you as best I can. Before I get into the weeds, though, a reminder, a word of caution, a disclaimer. Almost every state is different in how they characterize community versus separate property, how they treat community versus separate property. So if you are not in Washington State and you're wondering about this, you should at least Google your state and the rules, but you should really probably just talk to an attorney in your state to make sure that the rules are the same, because they are not always the same. They can be very different. So with that being said, generally, community property is referred to or is described as the property that you accumulate after you are married. In Washington State, anything that you accumulate after you are married is community property, unless you have done a prenuptial agreement or a postnuptial agreement, sort of define what is and is not community property. Generally, though, all the money that you make, all that kind of stuff, anything that you accumulate or buy or purchase, even if it's in one spouse's name or the other, is going to be considered community property. So, for example, I am married. If I took some money and bought a house in my name, if it was community funds that bought the property, then it's going to be community property, even though it's just in my name. Retirement accounts. So if I am getting paid right now and a part of that money is going into a retirement account that is in my name, even though it's in my name, because I earned that money after I was married, half of that retirement account is my spouse's. Okay? So keep that in mind. Separate property is going to be characterized as essentially the opposite of community property. Anything that you bring into the marriage is going to be considered separate property and will remain separate property as long as you don't commingle it or join it together with community property. For example, before I was married, let's say I had a bank account with $100,000 in it. Then I get married and I just keep that account over here on the side. I don't do anything with it. Or let's say I buy a car with it. That car is going to be considered separate property because I bought it with separate property. Now, let's say I take that $100K and I put it into a joint bank account. Yikes, not yikes, but it is going to sort of immediately become community property. Keep that in mind. When it comes to estate planning, inheritances are also considered to be separate property. So if you get an inheritance and you do not want it to be community property, do not put it into a joint bank account. Put it into a separate bank account and keep it separate. All right. This is important because when you die, if you don't have a will or a trust, separate property is treated differently than community property. Community property generally will go to the spouse. Separate property will be split amongst the spouse and any children that you have if you don't have a will. If you do have a will, you have the ability to give your half of the community property and all of your separate property away to anyone that you want. It does not have to be your spouse. Now, important note, this is not the same rule in many other states. In many other states, spouses have a right to a share of the estate, but not in Washington. You can give it all away. All right. Okay, hopefully that makes sense. You good so far? Excellent. Now, if you have a trust, some people get concerned because they create a trust and let's say that I have a house that is my separate property. I create a trust with my spouse. I should put the house into the trust, but I'm worried that putting it into the trust is going to commingle the property and turn it into community property. And that's not necessarily something that I want to do for whatever reason. I have good news for you. If you draft your trust properly, it will say that whatever property you put into the trust retains the character that it had when it went into the trust. So if it was separate property going in, and for some reason you need to take it out, it will come out as separate property as well. Okay. This is why it's important to have a good estate planning attorney on your side so they can set this stuff up, so they can educate you about these things so that you can make good choices. All right. So that is it. That is my rundown of separate versus community property. Hopefully this made sense. If it did, that's great. Like, comment, follow, subscribe, do all those things if you don't want to miss out. If you have questions, ask them. I will answer them. And if you want to talk with us about estate planning or probate and you want to do it for free, you can do so by going to cmslawfirm.com. All right, that is it for today. Hopefully you enjoyed this. If you did, that's great. I am Christopher Small. I'm the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. Appreciate you. And I will talk to you again soon. See ya.